Hi, my name is Brandon and I'm an intern here at the law offices of Amir Dibaei. Today, I will talk to you about the details of filing a small claims case in the city of Los Angeles. Just a disclaimer, none of the following constitutes as legal advice. There are a few details you need to know first before you can file a small claim. Parties are limited on what they can collect. Individuals can collect up to $10,000, while entities can collect up to $5,000 only. Also, depending on your claim, there are time limits you need to know to see if you can even file a claim. These are the statutes of limitations. If your case is a written contract, you can file a claim if the contract was broken within 4 years of the current date. An oral contract is 2 years from when the contract was broken. A personal injury is 2 years from the date of injury or when the injury was discovered. And fraud is 3 years from when you discovered you were defrauded. Once you have determined whether your claim can be filed, you need to find the nearest courthouse. The location is based on where the contract was signed, where the incident took place, where the purchase was made, or where the person or business is located. You can go to the Superior Court website and type in the postal code of the location, and the nearest courthouse will be shown. There are also costs to filing a claim, and there are ways to get the filing fees waived. Fees waived depend on whether you receive public benefits, if your household income before taxes is less than the amount stated in Form FW001, or if you don't have enough income to pay both household basic needs and court fees. If you do not qualify for these, it is $30 for a claim up to $1,500, $50 for a claim over $1,500 and under $5,000, and $75 for a claim over $5,000 and under $10,000. The first step is to file the paperwork. Go to the county clerk's office, which is the courthouse you determined earlier. Fill out the paperwork, which is going to be the basic information about your case, like who the plaintiff is and the defendant is. You then pay the court fees. There is also an option to file online through the Superior Court website, but that requires a non-refundable fee of $10. The second step is to serve the papers. You need to notify the defendant they are being sued. You cannot serve the defendant yourself, so you can either notify them through certified mail, a sheriff, or through a process server. Once the defendant is notified, the court will begin processing the claim. The third step is going to court. Here, you cannot have an attorney represent you. You need to make sure to bring all evidence like witnesses, receipts, bills or repair estimates, pictures of damages, or written contracts or documents to prove your case. The judge will also ask for you and the defendant to resolve the case, and if there is no resolve, the judge will hear the case. Also, if you have a witness, they may require additional fees, and you need to serve them subpoena in advance. Step 4 is the final judgment. The judge will give a final judgment once both sides have presented the arguments, and notify the parties of the judgment either at the end of the hearing or more typically by mail. The losing party can appeal the judgment, and if he or she needs, or if he or she does, the case will go to a more formal and strict manner where both sides have a lawyer. The last step is collecting the judgment. You must wait 30 days before you can collect the money, in case the losing party wants to file for an appeal. If he or she refuses to pay after that, there are legal ways to collect. If you have any questions about filing small claims or other legal issues, please feel free to contact our law offices at 310-481-6785. Again, that's 310-481-6785.